Good afternoon. The court calls the case of State versus Warden. We welcome Ms. Force and Mr. Montgomery to these historic arguments. This is the third day of virtual oral arguments for the Supreme Court in the court's 200-year history. So we welcome you today and those who are watching. Ms. Force.
Good afternoon. My name is Margaret Force, representing the state of North Carolina as appellant from the Court of Appeals opinion in State v. Warden that granted the defendant a new trial based on an erroneous application of the plain error review standard. I'd like to reserve 5 minutes of my time, please. My plan is to briefly summarize the evidence and then discuss the plain error standard and the two errors in the majority's application of the standard in this case. And then I would provide a short recap of the ineffective assistance of counsel issue that was not presented on appeal, since that was discussed in the briefs. Briefly, the state's evidence showed that the defendant called his daughter, whom we called Virginia in this case, into his bedroom when his wife was at work, told her to sink to her knees, close her eyes, and open her mouth. Then he unzipped his pants, put his penis in her mouth, and told her to move her tongue around. She was 9 years old at the time. After he was done, he told her to leave and went into the bathroom, and she heard him praying, seeking forgiveness, and saying he would not do this again. She was his daughter. It was years before Virginia disclosed what had happened to her, and when she did, she also disclosed that there were 2 other instances that were similar to this case and that he was charged with. And afterward, in those instances as well, she heard him praying, saying that he was sorry and would not do it again. When Virginia disclosed what had happened, she was 15 years old, and the circumstances were somewhat uncanny. The defendant's father, who she called Papa, called in anger to talk to Virginia and her brother because they wanted to ride back with him, their papa, instead of their father. And he asked them why they were treating their daddy this way when it was going to be Father's Day. And he said, "It isn't as if he molested you or anything." Well, Virginia quickly got off the phone and spent some time collecting herself and thinking about the circumstances, and then later that day told her mother what had happened, that her father had molested her. The state presented other strong evidence in this case, in addition to Virginia's testimony, including the testimony of defendant's sister, that she experienced similar conduct where the defendant also forced her to perform oral sex on him when she was a similar young age. And afterward, she heard him praying and asking for forgiveness for doing such a thing to his sister. Before we go through other evidence, because there is other evidence as well, I'm going to pivot now to the issue that's raised on appeal to this court. The Court of Appeals had held that evidence from a DSS investigator was improperly admitted in the case, and that the failure of the judge to exclude it on his own motion was plain error. Ms. McLary, who is a DSS investigator in Rockingham County, testified that the DSS investigated and substantiated abuse in the case, identifying the defendant as a perpetrator. In State v. Giddens, the Court of Appeals concluded, and this court affirmed per curiam, that plain error occurred in that case when such evidence was admitted. There, the court began its discussion by correctly stating that it was required to consider all of the evidence in the case to determine whether error was prejudicial under the plain error standard. Arguably, in this case, Ms. McLary's testimony was more limited than in Giddens, and it's clear in the record that she did not testify as an expert or give her opinion as an expert. She said so when she was questioned, but the state does not disagree that admission of her testimony was improper. Rather, because there was no objection was made, the question is whether there was fundamental error that probably changed the jury's verdicts. In Lawrence, this court said that the overuse of the plain error rule places an undue, if not impossible, burden on the trial judge. Generally, only an error which seriously affects the fairness, integrity, or public reputation of judicial proceedings will constitute plain error. And it is stated that a criminal defendant bears a heavy burden to demonstrate that the jury probably would have returned a different verdict had the error not occurred. The Court of Appeals in this case erred in two ways. First, it did not consider and evaluate all of the evidence in the record when it held that plain error occurred. And second, it did not evaluate whether, in light of the other evidence, the error was so fundamental that it probably changed the verdicts in the case. As to the first error that the Court of Appeals made, in Giddens, as I noted earlier, and in other cases from this court, the court has consistently instructed that the appellate court must consider all of the evidence in the record. But the Court of Appeals here said that it did not need to consider the full record, and instead it relied on argument. Often the arguments that are made to the jury don't even appear in the record on appeal. But here it relied on the argument of the prosecutor, that the jury, that the question came down to whether the jury would believe Virginia or her father. I want to make clear that the prosecutor's argument, when she identified different pieces that she referred to as supporting the credibility of the witness, did not refer to the DSS testimony that they had substantiated abuse. That does not appear in her argument. Although
Ms. Force, the challenge, the portion of the prosecutor's final argument that the Court of Appeals majority referred to specifically states that the prosecutor summarized the state's case, and then the prosecutor went on to say this case rises or falls on whether you believe the prosecuting witness or not. Is there any substantive evidence of the defendant's guilt in this case other than the prosecutor's, other than the prosecuting witness's testimony?
Well, this is not a case where there was physical evidence, because it was a case where the child delayed disclosure. On the other hand, there is significant evidence in the case that doesn't stem from the account that was provided by Virginia or testimony out of court about her out-of-court statements. And in fact, the testimony that came in from the defendant's sister doesn't rely on the credibility of Virginia's testimony at all, and is strikingly similar, and shows a consistency in his plan and his scheme that would be relevant to this case.
Would it be unfair to describe the state's case as consisting of, one, the substantive testimony of the prosecuting witness, and then secondly, other evidence that was intended primarily to persuade the jury that it should believe the prosecuting witness's account?
Well, often cases that have other evidence in the case other than that may corroborate the witness's testimony also provide other evidence in the case. In the case that the state submitted in the supplemental authority, the question that this court looked at in State v. Maddox was whether the other evidence needs to be overwhelming in the case. And it found that it does not, and the Court of Appeals incorrectly applied that standard. And it furthermore said it doesn't need to be direct evidence, it can be circumstantial. And so I can run through the other pieces of evidence for you in the case, aside from the testimony of the that Virginia gave, that about
as to the sister's evidence that you say was similar, that was 404B evidence. Can we consider consider 404B evidence in addition to the alleged victim's testimony in light of what the prosecutor said in closing statement That it was basically the alleged victim's word against the alleged perpetrator's word?
Well, it is not, I don't think that the cases specifically say you can or you cannot. The defendant has cited to state veto to say that in that case, the court did have evidence that was 404B evidence. In that case, though, the evidence was quite different. And again, this is a plain error review, as it was in tow. But in that case, you had evidence that was 404B evidence that wasn't as similar as it is in this case.
Court of Appeals looked to State versus Davis, the majority did. And of course, we're not bound by the Court of Appeals decision there, but it says, quoting from the majority, it is not plain error for an expert witness to vouch for the credibility of a child sexual abuse victim where the case does not rest solely on the child's credibility, unquote. It appears as though the prosecutor is couching the closing statement that Justice Irvin raised in such a fashion that it is the child's word against the defendant's word. And it would seem as though if we followed the spirit and the logic of the State versus Davis case, then indeed there would not be sufficient evidence beyond this 404B evidence that you're asking us to consider.
Well, I guess one of the things that the court needs to consider is whether this evidence, and because this is plain error, whether in that case the defendant has met his burden to show that this evidence was admission of this evidence, even though it wasn't objected to, was so fundamental that it changed the mind of the jurors in the case. And when you look at the other evidence in this case, there was compelling, important other evidence besides just the statement that, or the testimony that came in from Virginia. And I would include in that category the 404B evidence, but there was also other evidence. Virginia's grandmother noticed changes in Virginia that were about the time she was age 9, when she became less outgoing and more withdrawn. That goes to her circumstances beyond the credibility of her testimony in particular. Furthermore, Virginia's grandfather, whom she called Papa, noticed that Virginia often went to work with her stepmother when she was staying with her father. And in other words, the jury could, from this, infer that she was avoiding alone time with her father. His testimony also tended to undermine the credibility of the defendant's testimony to the extent that he said that this whole accusation came about because of animosity of Virginia toward her stepmother.
Does that kind of evidence steer you into the Giddens case then, which would be another aspect of if you don't have independent evidence that is in a position where it gives credibility more directly to the alleged victim's account, then you're running into 404B evidence, as we've already discussed to some extent. Now you're talking corroborative evidence that again seems to go into what the prosecutor's very direct statement was, which was you either believe the alleged victim or you believe the defendant once you take away the 404B evidence and the corroborative evidence that now you're saying comes from the grandparents.
The question for the court again is what the jury would take from that and whether the evidence was substantial for the jury putting aside the piece of evidence that was the DSS testimony on whether that changed the outcome in the case. And so I would go back to that again. There were some other pieces of evidence in the case. There was evidence that the defendant, this strange behavior of teaching her how to shave her legs when she was about the same age as the charge that was accused in this case, that he showed her how to shave her legs. And when he was confronted by her grandmother to say that this was inappropriate behavior, his response was to say that this was his child and she should mind her own business. The testimony of the witness was also unequivocal. The jury heard her testify. It also saw her out of court statement, the forensic interview that was conducted. And when you look at the defendant's testimony itself, as I said earlier, it was not very believable if you read the transcript. And furthermore, at the end of the trial, the instructions to the jury were that they should be the decision maker as to the credibility of the witnesses in the case. I would submit.
Ms. Force, isn't that credibility instruction given in basically essentially every trial?
I would think so.
And I'm just trying to figure out what to make of that part of your argument, because if that's a ground to fail to find plain error, I'm not sure how you'd ever find plain.
Well, the question again comes down to whether the testimony swayed the jury that was improperly admitted. And that's a balancing, and the state would maintain that there was sufficient evidence for the jury so that the fact that this evidence was in the record as well did not make a difference in the outcome of the case.
So you're not arguing that the mere fact that the state's evidence was sufficient to withstand the directed verdict motion, that's not the test for whether plain error exists, is it?
I'm not sure. I'm sorry. Could you say that again?
I mean, you referred a couple of times to the fact that the state's evidence was sufficient. To me, that sounds like we're talking about that the state's evidence was sufficient to avoid a dismissal motion for insufficiency of the evidence. You're not equating that standard with the plain error standard, I don't think, are you?
No, I'm not. I'm sorry. I understand you now. And the question is whether there is evidence in the case, apart from the testimony of the victim herself and her credibility, that would be influential in the case, such that the fact that there was this testimony that has been found to be vouching, whether that swayed the jury. And there was ample other evidence in the case besides the testimony of the girl herself, including testimony about her demeanor. And the jury had the opportunity to.
I'm sorry to interrupt. I'm sorry to interrupt you, but I had a question about that. Isn't this more like Tao or Toe, however you pronounce it, where the court pointed out that the only direct evidence of the incident was the testimony of the victim, and that therefore the credibility of the victim was all important, and that was kind of the last point that the court pointed to before saying, therefore, this is plain error. Isn't this more like that?
I think that is a comparison that the defendant, Mr. Montgomery, has made as well. And in our reply, we discussed the distinctions between the Tao case and this case. In that Tao case, the evidence that was the 404B evidence was not strikingly similar as it is in this case. The acts weren't as similar, and so there wasn't the same impact that you would see as in this case. And secondly, the expert testimony in that case, by comparison, we don't have an expert in this case in the DSS testimony, but also the expert was a very renowned expert, and the state emphasized the expertise of that witness. So
does it make any difference that, at least as I read the testimony of the social worker, that she described the substantiation decision as one that the agency made as compared to one that she made individually and personally?
I think I'm not sure what the difference is. This is not an expert witness. She said that it was her investigation. She was not testifying as an expert, and that would be a different witness in the case. You might make that argument. It was in the Giddens case, as I recall, it was the weight that would be given to an investigator that's more than a regular lay witness.
All right. The reason I asked the question was, at least as I read the testimony of Ms. McCleary, the question was, and what was the case decision that DSS or CSS decided on? We substantiated sexual abuse, naming David Warden as the perpetrator. That to me sounds like a joint decision made by a group of people on behalf of the agency, not an individual decision by Ms. McCleary. Does that make a difference if I'm right in characterizing the record that way?
I guess the question is whether this is an opinion that reflects on the credibility of the victim, and I don't have a good answer for that. I don't see the difference in the Giddens case. In this case, I might add that after the issue in cross-examination, the defendant went beyond the determination by the agency and asked about the consequences of that determination, so that the jury also heard other evidence admitted through the defense cross-examination that the defendant was told not to have any contact with his children, and the defendant's wife was directed to seek a change in custody. So there was other evidence that also reflects on the DSS determination. That was not the improper, what's couched as being opinion testimony vouching for her credibility.
Ms. Forrest, what about the testimony of Peg Stevenson? It seems like the Court of Appeals focused entirely on the testimony of McCleary. Did the defendant properly challenge on appeal the testimony of Ms. Stevenson?
That testimony was challenged before the Court of Appeals, but that issue did not come up to this court, and the Court of Appeals relied on the testimony only of the DSS witness. The dissent in the case referred to both of the witnesses. He referred to them both as experts, but he referred to both witnesses in his determination on review of all of the evidence rather than just focusing on the argument that was made by the prosecutor in closing argument. When he looked at all of the evidence, he said that it still didn't rise to plain error in the case, that the other evidence in the case was sufficient so that he would not find that the jury was probably affected by the error.
Well, in conducting our plain error analysis, do you contend we're allowed to consider Ms. Stevenson's testimony, or alternatively, are we required to only look at the evidence other than the McCleary and Stevenson testimony?
Well, all of the evidence should be considered in a determination of whether plain error occurred. And so you could look at all of the evidence.
Not all the evidence. Obviously, we're not looking at the McCleary testimony.
I see what you're saying. I think that the court can look at both the, assuming arguendo, that there was a problem with the Stevenson testimony and there was the problem with the DSS testimony. This answer is the same, that testimony both reflects bolstering of the credibility of the Virginia in the case, but there was other evidence, and the complete evidence in the case was substantial for the jury to find without regard to those.
You're saying
it still wasn't plain error.
You're saying no plain error, and you're saying we should, in our analysis, we should look at the evidence other than both Stevenson and McCleary testimony.
Well, I would qualify it this way. The defendant has characterized the testimony from Ms. Stevenson a little bit differently than if you read the full testimony, you ought to do that. And she does provide some assistance in the case when she talks about delayed disclosure and also the demeanor that she describes. But the jury looked at that demeanor for itself in the forensic interview. So with that qualification. If I have a few minutes, and I'd like to reserve time, but I do want to mention, in summary, this is not a case that related solely, we've talked about that quite a bit, but there is a striking similarity in the 404B testimony, and the issue is whether the other evidence in the case, the evidence was sufficient that the defendant has raised an appeal to change the verdict in the case. Briefly, as to the ineffective assistance of counsel, I'd like to mention that this was not an issue that was raised on appeal, as the defendant rightly said, but I would like to refer the court to the case State v. Land, which is a Court of Appeals decision that was affirmed per curiam, because there is a discussion that talks about both ineffective assistance of counsel and where it's applied in a case where plain error is not found. And otherwise, that I will rely on my brief and would ask to reserve my remaining time. Thank you.
Thank you, Ms. Force. Mr. Montgomery?
Am I being heard?
You are.
Okay. May it please the court, I am Mark Montgomery. I'm here representing the appellee, Mr. Warden. And as Ms. Force said, this case is about balancing. It's about balancing the relative weight of the improper vouching against the weight of the other evidence. In 3 cases now, Giddens, Tao, and this one, the Court of Appeals found the weight of the improper testimony was so great that its admission was plain error. This court affirmed both Tao and Giddens. In this case, as in Tao and Giddens, the properly admitted evidence was unremarkable. Corroborating witnesses, 404 witnesses, and so forth. I've done over 100 child sex abuse cases on appeal in my last 34, going on 35 years, and I've seen this sort of evidence in most of them. It's a standard presentation of the state's case. Here's what the Attorney General had to say in Tao, in its new brief before this court in Tao. The Attorney General summarized the state's case, the overwhelming state's case. Quote, in this case, the trial lasted 8 days. During those 8 days, the jury heard from the victim, her mother, who cried during a large part of her testimony, the victim's own doctor, who found irritation and a questionable vaginal scar sufficient to ask the victim and her mother about possible abuse, law enforcement personnel, a social worker, and a medical expert. The victim's accounts to all these witnesses were consistent. There was also 404B evidence from an older relative of the victim detailing similar sexual acts. For 8 days, the jury heard the testimony and viewed the demeanor of the witnesses. And the Attorney General insisted in that case that the evidence other than the vouching was so weighty that it was plain error, and this court agreed. So what sets Giddens and Tao in this case apart from the others is the weight of the expert vouching. It's weightier here than in Giddens and far weightier than in Tao.
I'm sorry, but did you say the expert voucher? Which of the witnesses at issue is qualified as an expert?
Both. Ms. Stevenson was explicitly qualified as an expert. Ms. McClary was implicitly qualified as an expert in State versus Agualo 2, 1988. A similar investigator was allowed to give similar opinion testimony. And this court held that by allowing that witness to give opinion testimony, that witness was being implicitly qualified as an expert. So we'd say that both Stevenson and McClary testified as expert, or their testimony ought to be evaluated as expert testimony in this case. And yes, Ms. Stevenson's testimony ought to be thrown into the mix in comparing the weight of the vouching versus the other evidence. So,
well, before you move on, Mr. Montgomery, I mean, I'm certainly familiar with the concept of implicit qualifications of experts, but Ms. McClary was not recognized in the presence of the jury explicitly as an expert witness, at least as I read the record.
I agree with you, Your Honor. The same is in Giddens. There was no explicit qualification of the witness. I'm sorry, not Giddens, but in Agualo, the 1980s case.
Does the facts that a witness may or may not be explicitly recognized as a witness have any legitimate bearing on the plain error issue as you?
I don't think, I would say no, Your Honor,
Why not?
because the jury is going to hear, without the judge having to say this person is an expert, they're going to be hearing about her expertise. That distinguishes this case from Giddens. In Giddens, the Attorney General went out of their way to say that, quote, there was no questioning about Kent, that's the investigator in Giddens. There was no questioning about Kent's credentials, experience, or proposed field of expertise. That's the state's new brief in Giddens. Here, we've got Ms. McClary not only testifying as to her experience as an investigator, but also her background and training, including certification as a forensic interviewer. She testified to her interviewing techniques and that it is her job to determine whether the allegations are true. And if we, and that includes DSS, the organization, if we believe the child, we substantiate, and we substantiate abuse by Mr. Warden. And also, adding to the weight of the McClary's testimony in this case, and the testimony of Ms. Stevenson, is they both referred to Virginia's claim as a disclosure. Well, disclose means reveal the truth. That's the everyday meaning of the word, and that's its legal meaning as well. Both the General Assembly and this court use it that way. Ms. Force used it that way in her argument. In our memo, we cite cases and statutes where the General Assembly and this court use disclose in that way. So when they use the term disclosure, they're telling the jury that Virginia revealed the truth.
Let's go back to, of course, the disclosure statements mostly are made by Ms. Stevenson, not by Ms. McClary, I believe. Is that right?
Yeah, Ms. McClary did on pages, I had it here a minute ago, pages 303 and 306 of the transcript, Ms. McClary also refers to disclosure. But you're right, Ms. Stevenson used that term ad nauseum, I'd say.
Well, putting aside the question of whether the use of the expression disclosure is or is not appropriate, you argued earlier that the testimony of Ms. McClary was stronger than the testimony of Dr. Everett and Tao. Why do you say that?
Well, I thought I already did, but
I might have missed it. My wife tells me that the steel trap that was my mind sprung a long time ago. So
I actually hadn't got to the point of talking about the difference between Ms. McClary's testimony and Dr. Everett's testimony, but I can do that right now. In Tao, Dr. Everett said that most children who've been sexually abused don't show any signs of it, don't show any physical signs of it. No problem there. But then she went on to say that the complaining witness in that case was one of those kids that have been abused but don't have any physical evidence. That's where she crossed the line, and that's where her opinion became improper vouching, leading to plain error analysis. In this case, and in Tao, the Attorney General characterized Dr. Everett's testimony like this. The Attorney General, in its new brief in this court, said it was a single isolated statement. It was an innocuous statement. It was an incredibly benign statement. Well, in this case, we've got testimony that's far from benign. It is the ultimate in vouching. Two experts testified, or one expert and one quasi-expert, if depending on how the court views the implicit qualification business. Two experts testified, if we believe the allegation, we substantiate abuse with Mr. Warden as the perpetrator, and Virginia's claim was a delayed disclosure of the truth. It doesn't get any higher, more improper vouching than that. It's the ultimate. If there had been definitive physical evidence of sexual abuse, that's the only time that an expert can come in and say that I believe the child. That was Aguala 1. The testimony was the child is believable. That's error. You can't say that I diagnosed the child with sexual abuse unless there's definite physical evidence of abuse and so forth. So here, without any physical evidence and precious little background evidence other than the child's statement or the teenager's statement, to go to the ultimate of saying this child has been abused the way she said she had by the person she claims abused her. That's as high as it gets.
I want to ask you about the 404B evidence.
Yes, Your Honor.
This case is a little unusual, and because there is that eerie similarity with the defendant allegedly saying a prayer and asking for forgiveness.
Yeah. Yes, sir.
Is a little more than we're used to seeing in terms of similarity in 404B. Well,
Yes,
why
right.
isn't that enough?
I don't see how that can stand up against the extreme vouching in the case. I will add that there was 404 evidence in Tao. What the Attorney General says is similar 404 evidence in Tao. In Giddens, there was something more impressive than a 404 witness. There was another complainant. There was a complainant about whom not only was abuse substantiated, but charges were brought and the indictment was brought and a verdict was returned. The 404 evidence in this case from my client's sister, nobody believed her. She went to the authorities, DSS didn't believe her. She went to the police didn't believe her. Her family did not believe her. And it supposedly took place at least 14 and maybe 19 years before the alleged abuse of Virginia. So I would say it's different, but I would say it's not very strong 404B evidence.
Well, let me ask you something else. I was a little troubled by the Court of Appeals majority's analysis of plain error. They seem to have relied almost entirely on the prosecutor's closing argument, which is not really the way it's supposed to work. They're obviously supposed to look at the evidence itself. What do you respond to that?
I would say that I wish they had, but I think there's a difference between enunciating matters that they considered and considering those matters. I mean, I think they said, well, we don't have to go any farther in the sense that this thing alone convinces us. It doesn't mean that they didn't consider that other evidence as well. I don't know what the answer to your
404B evidence, and with that, it's me, Mr.
Sorry. I'm sorry.
I'm sorry. When you have the 404B evidence, and then in addition to that, you have the corroborative evidence of the grandparents, the dissent seems to look at all of that evidence juxtaposed against the evidence that was improper, and seems to feel as though that should have been sufficient to go to the jury and it would not have amounted to plain error. What's your response to the dissent's position that the jury should just have been left to go ahead and do it in terms of making the outcome here, because that's something that should have been ferreted out by the jury as opposed to a finding of plain error as the majority's done?
I'm not quite clear on your question. You want me to talk about the so-called behavior changes that the grandparents were talking about?
That's a good start.
Okay. First of all, it's behavior change, singular. It came from one witness, the grandmother, not anybody else, not the child's mother, not anything else. But yeah, the grandmother did say that when Virginia was about 9, I'm sorry, I need to find my notes. Well, there it is. Okay, behavior changes. First of all, the experts didn't mention anything about behavior changes. If Ms. McClary or Ms. Stevenson had been basing their opinions on some kind of behavioral changes, we would have heard all about it. That's typical in child sex cases for the expert to come in and say, well, here's what sex abuse looks like. This is how the kids act. This is how the abuser acts. This is what it looks like. Equipping the jury to be able to evaluate the evidence and to determine whether it leads to a conclusion of sexual abuse. That didn't happen here. Both witnesses skipped that step, skipped the step about talking about what the characteristics of sexual abuse are, and basically said, trust us, we're experts, we know this kid has been abused based on what she said. And that's the only thing they based their opinions on, was what the teenager had to say.
But in talking about the grandparents' corroborative evidence, in terms of saying, as I did, that was a good start, in terms of what the dissent looked at in totality, that was properly admitted, which would be, according to the dissent, that evidence, the alleged victim's testimony, the recording of the alleged victim's interview with Stevenson, and the police report. The dissent looked at all of that and said that should stand alone against that which was otherwise improperly admitted. What is your response to the dissent's position that aside from the expert testimony that should not have been allowed, as both the majority and the dissent agree, that nonetheless it should not have gone to the jury because the majority says it was plain error?
I hope I can answer your question. The tape of the interview is just more corroboration. That's still just the child's statement. The police report is just what the child reported to the police. So again, it all goes back to whether her story is the truth or not. The only, the closest to independent evidence is the 404 evidence, which, as I argued before, is very weak. And the so-called behavior change that her personality, she became more demure, I guess, when she was about 9. Well, the state would have us say, well, that's because she was being sexually abused by her dad. Well, there's something else that was going on when she was 9. Her parents separated. Her parents split. And so from that point on, from when she was 9, she was having to be shuttled back between her mother and her father. That could, the jury may well have thought that would explain this so-called behavior or demeanor change. And I remind you that the girl's own mother didn't say anything like that. The grandfather didn't say anything like that.
Mr. Montgomery, you were talking about some of our prior cases a few minutes ago. What about State versus Stansel? That case, as you know, was also a case involving improper vouching or an improper opinion by an expert in this type of case. And we said it was not sufficient to show plain error. How do you distinguish Stansel?
Well, in Stansel, for one thing, there were some real behavior issues. There was, this is from Stansel, there was anxiety, compressed speech, abdominal pains, headaches. So arguably that was independent of the complaining witness's claim of abuse. And frankly, I don't remember enough about the rest of Stansel to be able to speak to that, but I do know this part about Stansel.
I have a question about TOW or TOW. One of the factors that the court pointed to is supporting the decision that it was plain error there to admit the vouching testimony was that the victim's reports of the incident were consistent throughout. Is that the case here, or were there variations in her? They were not consistent in TOW. But so my question is, how does this situation relate to that on the consistency of the victim's report?
Well, actually, what TOW said was they're not entirely consistent. Didn't say they were inconsistent, but they were. I would say consistency adds to the weight of the state's case. I'll concede that. Whether it's enough to overcome the plain error, I disagree with that. But as far as consistency goes, my client has consistently denied all this. Every time he was asked, he denied it. He got on the stand, was willing to take the stand and deny it.
I'm glad you mentioned his testimony. Yes, you mentioned the defendant's testimony because I thought I heard the state to be arguing that the fact that he didn't appear credible in his testimony is part of the factors that we could take into account in deciding whether there was plain error here, and that's independent of corroborating the victim's testimony, but that it's another factor.
I would agree that that you should consider his testimony as well as everything else in the case in balancing the good against the not so good, against the improper, I should say. Yes, the state characterized it as being incredible. I didn't get that from his testimony, but I don't have it in front of me right now. On the question of consistency, it is interesting to note that Virginia and her aunt, the 404 witness, my client's sister, were in contact constantly. They were close. Virginia said they spoke once or twice a week. That could explain, the jury might say, well, maybe that explains how consistent the two stories are and how consistent Virginia's story is. Consistency is something that at some point it can become rehearsal. It can sound like rehearsal, like an actress consistently repeating her line. So I don't know. I'll give the state some points for consistency. But I disagree that it's enough to overcome the extreme vouching that was here. I should also point out that her the statement was suspect. Her claim was suspect. Nobody saw or heard it. She claimed that she was abused in a trailer with no doors. Her brother, other people were there. At least her brother Bubba was there, who apparently didn't hear or see anything. The authorities spoke with him, and they didn't have anything apparently from him to add to the state's case. And as we know, she didn't say anything to anybody for years. So, yeah, she said it over and over again. I did want to correct perhaps a misapprehension about the leg shaving business. The grandmother said that the leg shaving stuff happened when the girl was 5 or 6, 3 or 4 years before she was allegedly molested. I guess the state was trying to say that this is some sort of grooming behavior. Surely, if that were the case, that one or both of the experts would have cited that as being part of the basis for their opinion in the case, but that didn't happen. I feel like, in terms of the ineffective assistance of counsel prejudice standard, this court made it clear in State versus Sanderson, as the United States Supreme Court did in Strickland versus Washington, that they're different. The two standards are different. So if the prejudice standard for ineffective assistance of counsel is the ordinary, what we call the ordinary prejudice standard, the one set out in 15A-1443A, a reasonable possibility that the verdict was affected. So if the court does not find plain error, which we think you should, and you remand it to the Court of Appeals, you should correct the Court of Appeals, the dissenter here, and the judges in the case cited by the Attorney General apparently are confusing the two and confabulating the two, treating them as the same, and they are not under both state and United States Supreme Court law. I'll try to answer any of the questions the court might have. I feel like I've addressed in my brief the state's other evidence, but I'm happy to talk about it some more. I've got 8 minutes and 18 seconds left if you're interested. Otherwise, we'd simply say that it's time to affirm the Court of Appeals once again and ask the court to do so. Thank you.
Thank you, Mr. Montgomery. Ms. Force?
Or that the burden in this matter of whether prejudice occurred as a result of the error is on the defendant, and he must show fundamental error, that it probably changed the outcome of the case. And looking at all of the evidence in the case, and in particular, the strikingly similar incident that occurred with the defendant's sister, where he prayed afterward, that the court should find that this was not plain error under the circumstances of this case. I'd like to point out that the Court of Appeals not only did not say what the standard is that they should find before or after they reached the conclusion that there was plain error, it did not say that it was required to weigh all of the other evidence. It didn't weigh all of the other evidence. And then furthermore, when it recounted the evidence provided by the defendant's sister, it didn't even mention either in her, I believe in hers or the daughter's testimony, that they related that afterward, that strikingly similar conduct of hearing him praying for molesting first his sister and later his daughter. I'd also like to go back to Toe. I believe if you look at the 404B evidence in that case, it was admitted for limited purposes of identity and motive. Here, the evidence was admitted for broader purposes, and the judge's decision on admission of that testimony recited all the different purposes, including the modus operandi and the scheme or plan. And furthermore, as Justice Hudson pointed out, the court noted that there were discrepancies in the account that the victim gave, and we have no similar discrepancies in this case. And that this, in conclusion, the state would ask that the court reverse the Court of Appeals decision for the errors that we've discussed. And if you have any other questions, I'd be happy to answer them. Otherwise, I'll rest.
Thank you, Ms. Force and Mr. Montgomery. We were glad to have you all here today.
Thank you, everyone.
Thank you.